Good afternoon, everybody. Welcome to 2026. Welcome to the new year. I hope you had a wonderful break, as I have. And now we are here, and hopefully you can learn something and start the new year with some interesting employer-sponsored information. First of all, let me introduce myself. My name is Agnes Kemenez, and I am the CEO and the principal lawyer at No Borders Migration, as well the CEO of the No Borders group. We're providing services, as you can see on the screen, in commercial, employment, property, and migration. But I certainly specialize in migration law, actually since 1998. Why we do what we do? For employers, it's really important to support businesses and companies to ensure a smooth operation of the business. And for our individual clients, we're really changing their life and we're offering them a way forward. Next slide, please. Okay. Regarding today's agenda and the discussion items, first of all, we would like to talk about employer sponsorship benefits and what type of visa options we have. There were some changes published by the department last year in November. Usually, I'm not sure how familiar with this you are, but usually the Department of Home Affairs make changes around March, July, October, November. So again, they made some tiny changes in November last year. Compliance, risk, and workforce implications, and how employers can sponsor with confidence. Okay, that's very, very important. Okay, next slide, please. All right. So we have done this little snapshot of the different sponsorship and visa classes available for employers to engage, retain overseas candidates. Okay, I'm sure some of you, or maybe all of you, done sponsorship in the past and you already employed overseas candidates, so it's not going to be new, but there is always a refreshing information. So first of all, we have a look at the top row, and that is usually the temporary visa stream. The temporary visa regime is the 482 and the 494. The 494 is for the regional area, and the 482 is all over Australia. Now, I'm sure you are all aware of the changes which came out after the new Labour government came into force. They no longer calling the visa stream, the temporary work visa stream, as TSS. They calling it SID. And the reason being is that under the SID, they made two streams. One is the core skill and one is the specialist skill. So why they have done that? Because some of the occupation, what was listed on the skilled list, were pretty much, I think, abused a little bit, used and abused. So they said, okay, for example, restaurant manager, we're removing it on the core skills and we put it on a specialist scale, because the salary on a specialist scale is $140,000. So we're not telling the employers that they cannot sponsor restaurant managers, but if they want to sponsor a restaurant manager, they have to pay $140,000 yearly salary plus superannuation. So, and there are quite a few occupations that is shifted to the specialist occupation list, but the other difference is that under the core skilled list, the salary level is around $76,500. So it's a huge, almost double the salary level under the specialist skilled occupation list comparing to the core occupation skilled list. So that's a big difference under the SID that has not been in place for the TSS visa regime. However, under the new stream, there are many occupations came back on the list. And what they have made as a change, that an employee doesn't require 2 years experience to qualify for the temporary visa. 1 year full-time experience is sufficient. Now, sometimes when businesses are employing people, they think that the employee requires only 1 year experience, which is absolutely correct. However, the employee and the nomination must meet the minimum requirement as it prescribed under the ENSCO description. So if the ENSCO prescribes that the employee must have a formal qualification, then the employee must have the formal qualification plus 1 year work experience, and the work experience has to be full-time, which can be part-time, but it has to be pro rata, okay? So it has to be 2 years part-time to qualify for the 1 year full-time employment. As I mentioned, the ENSCO requirement is very important, and sometimes if the employee does not have qualification, the employee maybe qualifies based on work experience. So as you may be aware, where we're talking about qualification requirement as a degree, the work experience can substitute the qualification, but the length of the work experience is 5 years. Otherwise, under the qualification as a certificate 3 or a diploma, the relevant number of years experience to substitute the qualification would be 3 years. So just remember for that, because sometimes, say right now I have a client where the employer is ready to sponsor, but the applicant will have the 3 years work experience only in May or June. Therefore, we have to wait even with the labor market testing, because you cannot advertise a position with, okay, the person has the relevant qualification and attributes at the time of the labor market testing when they actually don't have that, okay? So this is a very important aspect of the temporary skill regime. As you all know, the temporary SID visa, the 482, requires 3 distinct steps, and that is the sponsorship, the nomination, and the visa application. And as you all know, the current salary level is $76,500. I always advise my clients that $76,500, actually, you know, we select $77,000 or $77,500, but also the salary level must meet the market rate. It is very important. If the market rate for an occupation, say $80,000 or $85,000, then doesn't matter what the minimum salary level is, the minimum $85,000 has to be nominated on that denomination. Otherwise, the nomination can be refused, and therefore you cannot engage the overseas candidate. Also, it's very important if you have another employee within your organization who is working in the same position, that you may select that salary. So you're not making differentiation regarding an overseas candidate and an Australian employee. Also, it's very important that I think maybe 12 months ago, the minimum English language requirement has changed for the 482 visa. It's level 5 on each band. Previously, it was an overall level 5 for a technician, like a trades worker, but now it's level 5 on each band. There is really no other requirements under this visa stream. There is no age limit. Employees can be sponsored up to 67 years of age, whatever is our retirement age. There is no requirement otherwise, the country where they're coming from, where skills assessment is maybe required. So, very beneficial to employing overseas candidate. As myself, as a business owner, I also engage in overseas sponsorship, and I am also employing candidates. In fact, one of my employees who I sponsored initially, he is with me for 16 years, 17 years now. So there are benefits to employing overseas candidates. Under the regional stream, okay, which is the 494 stream, you must, or the employee must have minimum 3 years work experience and must have minimum skills assessment, okay? So under that stream, there is no deviation from a skills assessment. As I said, under the 482, that's maybe not a requirement. Depends which country is the from. There is a specific occupation list under the trades recognition Australia, where for tradespeople, certain country candidates or candidates from certain countries, they require skills assessment. But for the 494, that is an absolute must. And the English language level is the required English language level is level 6, okay, on each band. And English language test had to be done in the last 3 years. But the employer requires the same standard business sponsorship and requires the same nomination. In fact, under the 494, there is a requirement to seek a regional certifying body's approval. So that's very important. And also under the DAMA, if the regional skilled occupation, so if the regional location is under the DAMA area, like North Queensland, Townsville, South Australia, certain areas in Victoria, you know, in each state we have a DAMA facility. In those locations, the regional certifying body, which is usually the council, has to endorse the application. And that is also can be a 494 or a 482 visa stream. I'm not sure if anyone you or having employees in a DAMA area, but it is a very beneficial visa stream because lesser work experience required, the salary can be negotiated and can seek a 10% concession for the salary level. You know, if your employee is in trades and maybe the English language level is not as high, for some occupation, not all occupation, but for some occupation, there is a concession available under the DAMA stream. And there are some regime, like, you know, certain areas where the employee does not require skills assessment from the, you know, from the general skills assessing body. I mean with this is that not with us, not with trades recognition Australia, but the skills assessment is done by the local division of the council. So it's called the DAR, you know, the designated area approval body. So there are benefits, and also the benefit that once you have the endorsement for the business under the DAMA, that the endorsement is valid for 5 years and you can seek variation to the approval. However, they also gonna tighten this up in alignment with the labor agreement approval. The department has flagged that the labor agreement from now on will allow only one variation every 12 months. And variation, I mean by what type of occupations you would like to have, what type of age you would like to seek to vary. You know, you want over 45, between over 45 and 55, what English language level you would like to have. Under the normal labor agreement, the department is strengthening this and allowing only one variation throughout the year. So that's just the recent information from the Department of Home Affairs. If you wish to retain overseas candidates on a more permanent basis, and you can appreciate that the overseas employees would like to stay in this country, and it's not just from the Philippines or from the Asian countries, we have a lot of candidates from the States, from United States, a lot of candidates from England, Ireland, Germany. So I think people really would like to stay in this country, and they are very committed and very good workers. So if that's something which you can consider and you can offer them permanent residency, then after 2 years, paying on a temporary skilled visa with the same employer, the 186 visa would be an available visa stream as a permanent resident visa, okay? Usually is available as a transitional, as I said, so the employer can retain the services of a candidate for up to 2 years, up to 4 years actually. The temporary 482 visa is up to 4 years now for each occupation. But after 2 years, the employee can, seek change to permanent residency as well as the employer. If you are happy with the candidate employment and commitment to the business, then that's definitely a way to secure further employment. The current processing time to change over to a 186 can be between 16 months and 12 months. It depends, okay? There is also an availability for permanent residency as a direct entry 186 application. So if the employee is with you for 1 year and they would have all the attributes for the direct entry 186 visa, then certainly that can be facilitated. The requirement is the same as for the 482 visa. We don't talk about here sponsorship, we're talking about nomination. But the nomination has to be done by the same business which is sponsored the employee for the temporary visa. That's very important. And also, once the visa application is lodged, or actually the nomination is lodged and the visa application, then it doesn't matter that your 482 sponsorship lapses. But if it's not lodged and your sponsorship lapse for the temporary stream, then maybe the visa will be refused. So it's very important that until you get the application in, then you keep your standard business sponsorship alive. I mean, as you all know, the standard business sponsorship is valid for 5 years. And also, I didn't mention that at the 482 stream, that a 482 sponsorship can be sold as an accredited sponsorship from the Department of Home Affairs. Depends how many previous employees you have sponsored, depends how many years, depends on the turnover of your business, what is the majority of your workforce, 70% Australian employees, 30% overseas candidates. Then you can seek an accreditation. And once you are an accredited sponsor, the processing time is absolutely reduced to maybe a couple of days, okay? I mean, the visa application maybe takes longer because the visa applicant may require to undergo health check, and therefore, maybe it's an extended time, especially if you bring in candidates from overseas, that can extend a little bit the processing. However, once accreditation has happened, then you have a much faster processing. And if you are an accredited sponsor, it means that you have a very good standing with the Department of Home Affairs. The other issue is that under the skilled regional 494 visa, the permanent residency stream is no longer require an employer sponsorship. So once you employ the employee of yours, your candidate under the 494 regional visa, the visa is granted actually for 5 years, but after 3 years, the employee can apply for their own 191 visa, which is a permanent residency where an employee requires to demonstrate that they worked with the sponsoring employer for 3 years and worked in a regional area. Now, also, I would like to mention here that maybe if you have, an organization where you have different locations, like you may have a business in Cairns, or you have a business in down Adelaide or down in Victoria, somewhere in a regional area, then you can change the location of the employee as long as it is in a regional area in Australia. Same applicable for the 482 regime. Once you sponsor someone and you find that this person would better suited in another location in Australia within your business, the location is not Okay, so and regarding the labor agreement, we have listed here a number of them, which is a private arrangement with the Department of Home Affairs, and there is a company-specific labor agreement, there is industry-specific labor agreement, and on-hire labor agreement. The DAMA is also coming under the labor agreement, but once the DAMA is endorsed by the local council or chambers of commerce, then the labor agreement is an overarching agreement. So it is just a more of a technical or more of an administrative task to apply with the Department of Home Affairs. Recent changes to the on-hire labor agreement is that the salary has been changed, or the salary level, and under the on-hire labor agreement, an employer who has the labor agreement in force must pay minimum 20% extra in addition to the base salary. So just remember, this came out in November, that the salary level has to be above 20%. So 20% above the minimum salary level. So $76,000 plus, say, $15,000, so it would be around $90,000 what an on-hire applicant has to be paid by the on-hire company. Next slide is talking about the slight changes what came into force in November last year, and I may just gonna read this a little bit and use my documentation to share it with you. It's not, really, these are just technical changes, okay? So it's not affecting the sponsorship, but what the Department of Immigration wants to ensure the compliance of the sponsorship stream, okay? They recently we came across with quite a few companies where the department has monitored the sponsorship obligations. As you all know, the sponsorship has certain obligations that's listed on the department's website, and the key elements to that is that the company pays the relevant salary with the superannuation, as usually you pay for an Australian employee on a fortnightly or monthly basis or weekly basis, whatever your payroll system is, and you pay the superannuation. The other very important aspect is that the employee does the same task as it prescribed in the job description. All right. So the other, slight requirements are that the employer must avail themselves to provide evidence when the department is doing the monitoring, that if there is a fallout between the employer and the employee would depart Australia, the employer must pay a one-way ticket, which means repatriating the employee back to the home country. I haven't really, I think in my 29 years experience, there happened once where an employee required a repatriation, so buying a ticket, but that's a one-way ticket. And these are part of the obligations. There are other obligations, but I'm sure that all of you would meet with those requirements. And they just would like to strengthen this and make sure that the overseas candidates are not exploited. Okay, I mean, unfortunately, we come across with that, many times, not just with small businesses, but at the large scale of businesses. Okay, so key sections of the reforms: expanded visa cancellation powers. Okay, so if the sponsor is not compliant and the sponsorship is suspended, cancelled, or the employer barred, then the visa applicant visa can be cancelled, okay? So at the moment, as you all know, a visa applicant can transfer to another employer within 6 months of the employment ceases with you as a sponsor. I think the department would like to strengthen this, that if something happens, then the cancellation will come into effect and the visa can be cancelled. It doesn't mean that the sponsor and the applicant cannot appeal against the decision, and it doesn't mean that the employee cannot seek work rights, but that's just additional steps what an employee has to seek, okay? So it's very important. And whenever the Department of Home Affairs would inquire about the sponsorship obligation, I strongly recommend to seek legal support for that, because I have saved so many employers in the past from canceling the sponsorship or suspending the sponsorship. It's just absolutely worth it to seek professional support at that stage. Very rarely is happening, and as I said, if the sponsorship is an accredited sponsorship, it's very unlikely that the department will, do monitoring, except if you are in grave breach of the requirements. Okay, clearer application of obligation to primary and secondary applicant. As I said, listing the secondary applicant is really not that important for this under the sponsorship. The only issue is if they are husband and wife and they need to be repatriated back to the home country, then you would require to pay for the secondary applicant repatriation as well. So that's where the secondary applicant comes into the picture, okay? And that's why when you're sponsoring those couples, you must undertake or you must provide a statement that you appreciate and understand and accept that the visa applicant would have a secondary applicant attached to the visa. You don't need to employ them or anything like that, but just acknowledge that you are aware of that. Clarified ENS 186 TRT rules. Recent clarification confirms, that the time worked with the approved sponsor counts towards the ENS 186 TRT. Here I just would like to mention, if you intend to offer later on a permanent sponsorship for an employee who you engaged or a candidate, then it's worth to consider you employing that employee for 2 years, 3 years, or 4 years. So if your organization has a longer extended vacation period, like at Christmas time, they are, you may have shut down and you ask your employees to take unpaid leave, okay? In that situation, our recommendation is to do the sponsorship and the visa for minimum 3 years, okay? So it's actually not the sponsorship, it's the nomination, all right? So you nominate the applicant for a minimum 3 years if you have unpaid leave regime in your workplace. If you have no unpaid leave regime, then the employee can take, sick leave, can take holiday leave, would not affect the period of employment, okay? And what is available at the very last of the second year, the employee can seek a permanent residency transition, and the employer can seek the nomination to the transitional 186 visa. All right, so it's very important to remember, if the employer would require to take unpaid leave, make sure that the nomination is happening for 3 years. The importance of this is really how much money you spend on a SEF levy. If the SEF levy is for 3 years, it's $3,600. If the 2 years is $2,400. However, if there is a requirement to extend the 482, then it's a whole new application and whole new SEF levy. So it is very important to decide at the very beginning. So this is really strategizing your sponsorship and your workforce for the future. Okay. Offshore, that is a huge change in the migration amendment or migration regulation, that if someone is offshore and you're sponsoring them and the department decides to refuse the nomination, not the sponsorship, but the nomination and the visa, then you as a sponsor can seek a review of that decision. They stopped this for a while. They used to be in force maybe 20 years ago, but then that has been changed, and overseas application could not have been reviewed. Okay, ART, or it's called previously AAT, has no power to review the decision. If the visa applicant was onshore, there was no problem. Okay, so there was always a review rights, but offshore applicants could not have that reviewed. This is changed now. Offshore applicant can seek a review, but through the sponsoring company. Okay, so that is very important, and it's a big change. Okay, so sometimes immigration can do reasonable, changes. Sometimes they can't. Okay. Clearer rules on when sponsorship obligations, what is this? Clearer rules on when sponsorship obligations ends, okay? So that is usually when the visa when the visa comes to an end, okay? So if the visa applicant is applying for a TRT and they are on a bridging visa, your sponsorship obligation is still in effect, okay? But if a 2-year visa comes to an end and the employee may change employer, went to another employer, or get sponsorship by someone else, and the nomination has been taken over, then your obligation ceases. Okay, so the important thing is anything and everything regarding employment is as relevant as to any other Australian employees, and that's coming under the Fair Work rules. Okay, so any termination, any general protection issues, any dismissals, anything, you have to be compliant with the Australian Fair Work rules. Migration is different. It's just a sponsorship, and if the applicant makes some application because someone abused them or something, then that's maybe investigated by the Department of Home Affairs. Have you been compliant with your sponsorship? But to tell you the truth, I haven't seen that in my practice, maybe just a couple of times in 29 years. So as long as you are compliant with Fair Work, that is sufficient. Okay. Next slide, please. Oh, sorry. Why this? Okay. So when sponsorship arrangements are set up correctly, a PR timeline, as I have explained, okay, 2 years, 3 years, or 4 years, depends if you just want to keep the employee for 4 years, and then you think that the employee may, you may terminate after 4 years, then the 4 years is fine, okay? And skilled workers are more likely to stay and more to be committed when they see an opportunity for permanent residency, and engagement and productivity are protected. So it's important that you can be sure that the employee will be with you for the 2 or 3 years, what the nomination period was. But as you all know, and as I know myself, nothing is sure these days, okay? Next slide, please. All right. Practical impacts on employer sponsorship strategy. So as I said before, you have to maintain your standard business sponsorship approval, valid for 5 years, so you don't need to really review it, very often, but just make a note and keep your standard business sponsorship approval in your HR department, or your HR consultant or employees have to have a copy of that available. Ensure every nomination aligns with the approved duties and salary levels, I would say here. Act quickly if the sponsorship status changes. And by that is if you let the employee go and that was terminated for some reason, then you notify the Department of Home Affairs that the employment has ceased. That's the only thing. And I think you have 7 days. I mean, if you notify them within 21 days, nothing is really going to happen. But usually 7 days after the employee has left. Okay. Well-managed sponsorship framework supports long-term staff retention and smooth transition to their permanent residency, and possibly a longer employment with your organization. Okay, next slide, please. Okay, employers compliance checklist. So that's what I talked about. Ensure SBS is current and aligned with your work plans. All right. I mean, as I said, if you want to bring in more overseas candidates, it's worth to think of meeting the requirements for the accreditation, because that can support your engagement of additional workforce, and do it faster. Review sponsored employee status, align job duties and salaries, as I said, ongoing actions, monitor the obligations and update records, make sure your payroll is up to date, all the what the visa applicant or the employee is entitled to be paid. Seek advice before role or entity changes, as I mentioned to you. Sometimes we have clients who they sell the business, and then they have overseas candidates in a sponsorship. Contact us immediately, or contact your relevant advisor that this has happened, because the new entity have to take over the sponsorship and the nomination. All right. Key takeaway for employers, okay, just the technical changes, employer-sponsored migration demands precision, compliance, forward thinking, okay. Businesses that aligned early will protect their workforce and strengthen their long-term talent strategy. It's just, have a plan, as with everything. Work out your employment contracts. I mean, you all know, when you employ someone, you need to pay a base salary. If they want to, if you would like to reward them with bonus payments, don't put that into the employment contract. Don't put into the employment contract, how much overtime you want to see them, working. You might say additional overtime as it's may required. You can put in, or if you want to do things, and strengthen the employment contract, you can always do an additional deed, a statement, a deed of statement. Okay, these gonna be the requirements, or do a KPI attached to the employment contract. But immigration requires a normal employment contract, and that has to meet the requirements of fair work. Okay, next slide, please. Oh, yes, we're coming to an end, okay? So if you would like to have a complimentary, 30 minutes discussion with myself or some of my very experienced colleagues in the business, please, get your QR code. And otherwise, what we offer is an expert guidance, in regards to sponsorship, nomination, and really visa application, okay? Employer-sponsored migration is now part of a broader workforce. We're really having a lot of businesses who are now engaging overseas candidates' employments. We understand that we don't have enough skilled workforce in Australia, especially in construction, hospitality. Yesterday, I talked to someone where they, I think, engaged about 100 cooks and chefs and I don't know, hospitality employees around Sydney. So it's really in great demand, and it's very important that you prepare for future expansion. All right. Align sponsorship arrangement with employment contracts and workplace obligation. That's what I raised before as well. Okay. Ensure compliance, with immigration, and move forward with confidence, clarity, and commercial obligations. Okay. And commercial certainty. I think that was my presentation. And I have the question and answer time now. So it's your time. I talk too much. So thank you for listening. Any questions? EJ, could you please help me?
Yes, Agnes. So everyone, feel free to leave your questions in the chat box. If you have any questions related to our topic today, feel free to leave a comment Also, if you have more personal questions, more in-depth questions for Agnes, feel free to scan the QR code to have a free consultation with her. So we have a first question, Agnes, from Sue.
Yeah, can you repeat the question? I lost the question. I saw that and then now it's disappeared from my screen.
Sure thing.
Thank
From Sue, her question is there an age limit on the 186? Is it possible to submit a 186 for someone over 50 years old?
Okay, very good question, Sue. Thank you for raising this. Absolutely. A 186 visa application under a general 186, which is available in the big cities, the age limit is 45. Okay. Under the labor agreement, if you have a specific labor agreement because of age, okay. But then if you're seeking a labor agreement, there is something also very important, that you can only employ candidates in an occupation that is not on a skilled occupation list. So candidates, say, for example, a fencer, right, who does fencing, that is not available under the 482 stream. So you can seek a labor agreement, and the labor agreement would give an opportunity to have the candidate up to 55 years of age, or you can seek variation, simply over 45 years of age, okay? That's just under the labor agreement. Also, the age limit can be different under the DAMA regime, sometimes 50, sometimes 55 years of age. So if you have regional places, not just the head office, say with us, we have an office in Adelaide, okay, and I have a little facility in Cairns, I would be able to nominate someone in those locations if they are over 45 years of age for permanent residency under the DAMA stream, because the DAMA also has 186 and also the 482. But under the general stream, 186, only 45 years is the age limit. Now, there is also a little adjustment to that, okay? And there is always an exception. If the employee is paid a high salary, and I'm talking about here, I think the salary is 180,000. So if someone is, a senior manager, a CFO, a CIO, I mean, in those occupations, you certainly pay $250,000. So if their salary is over 180,000, then if they're working with you for 2 years, doesn't matter they are over 45 years of age, they can gain permanent residency. Have I answered your question, Sue?
Thank you, Agnes. We have another question from Sue as well. It's regarding the 482 visa.
Yes.
If you already have a staff on the 482 visa, do we need to go through the whole advertising process to renew?
Depends how long is the employee is with you. If it's only under 2 years, yes, you do need to do a new labor market testing. If it's 2 years and over, you don't require to do a labor market testing. Okay, but they have to work with you under the 482.
Thank you, Agnes. We have another one from Felix.
Yes.
I have a new mother returning from maternity leave who is on a 482 visa. She would like to return on a pro rata basis between 25 to 35 hours a week, but I am unsure of how this may impact her sponsorship. Is there any advice here on how we can best support her?
Okay. They can return for a 25, 30 hours a week, okay, giving her the opportunity because she has been, she is having a little baby. However, you must pay her a full-time salary. So sometimes there is an availability, but the salary has to be paid, okay, as you would pay a full-time employee. Otherwise, you cannot keep the sponsorship alive. Okay. And I saw Sue was asking a question before, how many times you can renew your 482, as many times as you like, Sue. There is no issue with that, okay? Long as the visa applicant and the business is compliant with what you have proposed to do. EJ, any other inquiry?
None so far, Agnes. I think Monir is raising his hand for a question. If you have any questions, Monir, feel free to send it via chat. Thank you.
I really like this, type of active presentation, because we all have some interesting questions.
I think that's all we have for now. Again, thank you so much, everyone, for attending our webinar. If you have more in-depth questions, more personal questions that needs more detailed answers from Agnes, feel free to scan our QR code for a one-on-one consultation.
Thank you, Ide, for the moderating the meeting, and thank you for everybody. And we might gonna reach out, see how you're going, and if you require anything in the future. I wish you an amazing 2026. As you all know, we're gonna have the year of the horse, okay? And horse is always bringing lots of good things. So I think 2026 is an awesome year for all of us. Have a lovely day. Thank you so much, everybody.